Hello, my name is Michael Tessaro and I prepared this ACCC case note entitled Benzing the Rules, which will look at ACCC and Mercedes-Benz Australia Pacific Proprietary Limited case. And I know it's a very bad pun, but the idea behind it is that I think there have been a lot of agreed penalty cases coming to the federal court recently which have not had a very clear explanation of how the agreed penalty was arrived at, which has put the court in the position of having to be very creative in working out how to justify the penalty in the light of the statutory regime. And I don't think that really should be the role of the courts. Rather, the regulators should be working out how the penalty is consistent with the statutory regime and putting that reasoning to the court. Bit of background about myself: I'm a competition and consumer lawyer, and I've been running my own practice, Tessaro Legal Consulting, for the last 14 years, and I help companies with competition and consumer law matters. One bit of relevant experience that I have was as the ACCC approved independent auditor for the McLaren Automotive Takata rear bag recall. So I was retained to report on how they comply with their obligations under the mandatory recall notice. It was a pretty good one to do. There were very spectacular cars. There's a McLaren Senna, which I didn't get a chance to drive, which is a bit disappointing, but it was a good experience to work with them on that matter. Prior to that, I worked at the ACCC for 15 years in a variety of roles, including as Director of Enforcement. Outline the presentation, I'll start with the background to the case, then discuss the decision of Middleton, which I think is a very good decision, and he does try to grapple with all the relevant factors. Then look at the implications of the case and some other cases that have recently gone through the federal court, then finish with some commentary. Now, the background of the case starts, I think, in February 2020, when the ACCC accepted a court enforcement undertaking from Mercedes in relation to concerns that they had not initiated a recall of certain C-Class and E-Class vehicles. So this was a concern the ACCC had, and Mercedes responded by obviously expanding their recall to include these vehicles and providing a court enforcement undertaking. Then in August 2021, the ACCC commenced legal proceedings against Mercedes-Benz, alleging that they had engaged in conduct which minimised the risk of the recall. And specifically, they claimed it was 73 occasions where Mercedes call centre staff had made statements or sent emails to consumers which suggested that the recall was not as serious as it actually was, and that was a misrepresentation. Now, when the case came to Middleton, it had been agreed in all respects, and the fundamental allegation was that ACCC believed there had been breaches of section 127(1) of the Australian Consumer Law, and as you can see, the number of breaches has reduced significantly from the press release. It's gone from 73 down to 27, and you can also see that it's only related to oral representations, doesn't actually relate to any written representations. And there's two types of representations of concern. The first is, on 23 occasions, Mercedes call centre staff said to customers that the recall has been undertaken as a precaution. So that was the precaution statement. And that was clearly false, because the recall was being undertaken as a mandatory or compulsory recall that the minister had called. And then the second allegation related to these no incident statements, where on 4 occasions, call centre staff told customers that the beta inflators had not had any faults or caused accidents, injuries or deaths. So again, minimising the seriousness of the recall. The ACCC sought declarations of pecuniary penalties and costs, and importantly, Mercedes-Benz admitted all the facts that constitute the contraventions, did not oppose any of the relief, and agreed on a penalty of $12.5 million. So the first thing the judge had to determine is whether there'd been a breach, and the key issue here was the Communications and Engagement Plan, the CEP. And this was a document that had to be prepared by manufacturers that spelled out how they were going to comply with the notice. They're very prescriptive in terms of the language you're going to use, draft letters, size of fonts, colour of fonts, dates when you were going to write to consumers, dates you're going to chase them up, and so on. And so these CEPs had to be prepared, given to the ACCC approval, and then people like myself, independent auditors, had to make sure that the manufacturer was complying with all the elements of the CEP. So what happened here was the court was satisfied that the statements made to consumers did not comply with the obligation under the relevant notice to use attention capturing and high impact language. With the breach established, Middleton moved on to a consideration of the agreed penalty, and he started looking at the specific deterrence issues. So the first was obviously that Mercedes had breached a recall notice, which was aimed at protecting the public. So that was a factor in favour of a large penalty. Also, he noted that Mercedes did not have a formal system for monitoring the calls made by its call centre, and he considered that was a failing. And that's a very common thing that many call centres operate, which is effectively to select a number of calls at random and for a senior manager to listen to those calls on a weekly basis and identify any problems. So that's a common thing to see in many different industries, and the failure to have it here obviously counted against Mercedes. He also thought that the previous undertaking in February 2020 was relevant, and then he observed that there were 27 occasions where these statements have been made, and that should be seen in the context of 52,000 interactions with customers. So the suggestion is here that there's a very low level of non-compliance. I think it probably begs a question as to whether those 51,900 and whatever calls were also compliant with the law. I don't think anybody really knows. He also noted that all the consumers to whom these statements have been made had their vehicles recalled and the inflator removed, and so they'd suffered no loss and damage. And then finally, he noted that Mercedes had cooperated with ACCC, and the key thing here, at the earliest opportunity, when the issues were first raised with it. So that's really a major factor in terms of a significant reduction in the relevant penalty. Then he looked at the general deterrence considerations, and the first one's very significant. Compulsory recalls are about protecting the public from danger, and so a breach of those is a very serious contravention and one that needs to be subject to a large penalty to ensure that other companies don't engage in similar breaches. He also noted the motor vehicle industry is very large, so companies that are subject to recalls are likely to impact a large proportion of the Australian population. It's clearly correct in relation to Mercedes. They're a big brand, and so they've got lots of customers. It wasn't quite the case with McLaren. I think I had to order 330 vehicles in total. Then he moved on to another important factor, that contraventions and mandatory recalls must attract appropriate penalties in order to maintain consumer confidence in the recall process. And I think that's a very good observation, because the Australian public, I think, has quite a high degree of confidence in our voluntary and mandatory recall system, and then if there's a breach of the law in relation to that, a large penalty needs to be imposed to restore the Australian population's confidence in that system. Finally, he makes a very strong observation that corporations should be left in no doubt that a strong internal compliance program is not optional. So this was interesting, just making that point very strongly, that internal compliance programs are something that every company must have. They're not an optional extra which you may seek to implement. And I think it should be seen in the light of the recent decision by Justice Downes in the J. Hutchinson case, where she declined to make orders implementing compliance programs for both Hutchinson, the builder, and the union, the CFMMEU. Then he considered the course of conduct, and this is very relevant because usually the course of conduct dictate which events will be subject to a penalty. And so here it was pretty straightforward. He identified two courses of conduct: the precaution statements and the no incident statements. So two courses of conduct. Then he had to look at the maximum penalties, and the first observation he made was the decision by the High Court in Pattinson early in the year, which made two key findings. The first was that the primary, if not the sole purpose of civil pecuniary penalties is to protect the public by ensuring that contraventions of the law are deterred. So that's what civil pecuniary penalties are all about. The second observation was that the maximum penalty for a civil pecuniary penalty breach is not reserved for the most serious case imaginable. So that's a line of case law that you're seeing coming through in many judgments, particularly in the federal court, that the maximum penalty is reserved for the most serious conduct, and the conduct in the current case is to be measured against that archetypal worst conduct. Well, the High Court said that that's not right, that's not the correct approach. So really the approach is the maximum fine will be imposed where the court's satisfied that only the maximum penalty will achieve compliance and will deter the relevant company or individual from further contravention of the law. So then he had to look at the two fining periods. Prior to September 2018, there was a different fining regime under the Australian consumer law with a maximum penalty of 1.1 million. So he concluded that given there were 6 contravening statements made before that date, the maximum penalty for those breaches was 6.6 million. Then he looked at the situation after the September 2018, where the laws changed to $10 million, 3 times the value of the benefit, and or 10% of turnover, whichever is the greatest. So on first blush, you'd say, well, he's going to use 10% of annual turnover because given the turnover of the relevant Mercedes entity was about $3 billion. But the point that he noted was the language in the statute says that you start at 10 million, you move to 3 times the benefit if it's higher than 10 million, and then you move to 10% if the benefit can't be determined. Now here, what he noted was that it was agreed between the parties that Mercedes made no gain from the omitted conduct. So that meant that he couldn't move to the third limb because there was no benefit. And he had to basically go backwards and use the $10 million penalty. Now, that was a really interesting observation. It'd be probably good if he discussed it in a bit more detail in his judgment, but that meant that the relevant fine for the 21 contravening statements made after September 2018 was actually $10 million and not 10% of turnover. Now, if it had been 10% of turnover, that would have been around $295 million per breach, as opposed to 10 million per breach. So that was a very, I guess, lucky break for Mercedes, because it could have been looking at absolutely astronomical fines. So then he does the maths and he works out that 21 breaches at $10 million is 210 million, and then he adds a 6.6 from the pre-September breaches and ends up with a total maximum penalty of 216.6, which he immediately concludes is too high, outside the appropriate range, and oppressive. He then discusses the Allsop decision in ACCC and Coles, which is the Irish bread case, where it introduced this idea of instinctive synthesis. So the way the judges go about working a penalty under a civil pecuniary penalty regime is to undertake a single evaluative task in which all the considerations that rationally touch on or inform deterrence are taken into account and balanced. So as you can see, it's not a mathematical or sequential process. In actual fact, Allsop dismisses those as not being the correct approach to take. Rather, it's sort of putting all the factors together and looking at them and determining what would be an appropriate penalty. So it's very instinctive as opposed to being sequential or mathematical. Then he looks at the submissions made to him by the parties about the penalty, and they've submitted that for the precaution statements, a total penalty of 10.1 million is appropriate, and that was broken up into $300,000 for the 6 precaution statements made prior to September 18 and 9.8 for the ones made after September 18. And then in respect of the no incident statements, they're all made after the September 18 date, so the total penalty there was 2.4 million, which made a total penalty of 12.5 million. Now then he goes back to consider why the maximum penalty of 216.6 million is not appropriate and outside the range. And the first thing he notes is that the penalty of 12.5 million is, in his view, will not be seen as an acceptable cost of doing business either for Mercedes or other players in the industry, and it would be appropriate penalty to deter future contravention. So there he's clearly applying the reasoning of the Pattinson case. Then he concludes that the contravening conduct was not reckless, deliberate, systematic or covert, which I think is largely true. There's probably a little bit of an argument that not implementing a monitoring process for your call centre is a bit reckless, but I think on balance probably a fair comment that the conduct was really through inattention rather than any recklessness. He also noted that senior management were not involved in the conduct, rather it was 5 contractors. And then he says that the contravenor's size and financial position was a relevant consideration, although he doesn't actually mention how large their turnover is or what their financial position is. As I said earlier, they had a turnover of about $3 billion, this particular entity. Appeared to be very profitable. Then he concludes that the Mercedes conduct did not cause any loss to consumers. They made some misrepresentations, but as I said earlier, the consumers had their vehicles recalled and repaired or replaced the airbag. And he says that the absence of loss or damage is a matter in mitigation. I don't know if that's really true. You'd assume that if there's no loss, it's a neutral factor, but if there's significant loss, that would be a factor in an aggravating factor and result in a larger penalty. Then he also notes that Mercedes had not previously been found to have breached the relevant legislation, which I think is partially correct, because realistically they had been found to have not complied with the recall earlier and given an undertaking. So really this factor, I think, really should have gone against them. Then, after looking at those factors, he considers that Mercedes made no financial or other gain from the illegal conduct. They hadn't profited from it. They'd spent $100 million doing the recall over 3 years, and so they were no better off from having engaged in this breach. He also noted that Mercedes had fully cooperated with the ACCC, and that is a significant factor in reducing the penalty. So then he looked at then you look at the penalties in the context of the maximums, and you had $300,000 for 6 precautionary statements made prior to September 2018. That's $50,000 for each breach, which was subject to a $1.1 million penalty. So that means the penalty imposed is 4.5% of the maximum. Then you look at the $9.8 million for the 17 precautionary statements made after September 2018, and that's $576,000 of a maximum $10 million. So that's again 5.76% of the maximum. Then finally the $2.4 million for the 4 no incident statements, $600,000 each, maximum penalty of $10 million, 6%. So when you're looking at the penalties of 4.5, 5.7 and 6% of the maximum, it's hard to see that they are really significant penalties that are going to achieve general specific deterrence. There seem to be very low fines to impose in the circumstances. But the question is that the right approach? It just seemed to me that after identifying 2 courses of conduct, the better approach might have been to bunch all the conduct into 2 categories. So in relation to the first course of conduct, you had the 6 precautionary statements made before September 2018, so that would be a maximum penalty of $1.1 million. 17 made after September 2018, again, all one course of conduct, so $10 million. So a maximum penalty there of $11.1 million. Then the second course of conduct, 4 no incident statements made after September 2018, maximum penalty $10 million. If you're taking this course of conduct approach, you would have resulted in a maximum penalty for this conduct of $21.1 million, which sounds more in the ballpark in terms of what they did. You couldn't say what they did was particularly widespread or damaging, and a penalty of $216 million doesn't probably reflect the seriousness of the conduct. It clearly is too high. But this approach, you end up with a maximum of 21.1. And then when you look at the penalty imposed as a proportion of 21.1, it does appear to a very significant penalty. It's actually 59% of the maximum. So that's a penalty that I think is appropriate given the conduct engaged in, and a much healthier percentage than between 4 and 6%. Now, what I said earlier was there'd been a range of cases that come to the federal court in recent times with agreed penalties, and there's been a lot of confusion out of the court as to how the penalties have been justified. Sort of one case was Yates in ACCC in first class slate roofing, where the penalties of $420,000 were imposed for bid rigging. And in the judgment, the judge doesn't seek to identify what the maximum penalty is. Rather, he just imposes the penalties and says they're appropriate. But the maximum penalty against first class slate roofing was $280,000 compared to a maximum to make and give effect to a cartel agreement of $40 million. So as you can see, contrasting $280,000 actual fine with $40 million would have been a very difficult exercise. So there doesn't seem to be any way those 2 numbers can be reconciled as being consistent. Secondly, Colvin in AER and Energy Australia doesn't refer to the patterns of case at all, which had come down, which is somewhat surprising. And that as a result, he agrees to an agreed penalty, which is equivalent to 0.2% of Energy Australia's turnover, which seems a very low number and one that's not likely to achieve much specific or general deterrence. Then Mashinsky in AER and Origin Energy took a very confusing approach. Initially, he used the 10% of turnover amount, even though most of the conduct occurred under the earlier penalty regime, and that's not the same as the ACL has a different penalty regime. But Then he dismissed the 10% of turnover amount as being so large that it was no meaningful penalty. And then he agreed on a penalty which was equivalent to 0.12% of Origin Energy's turnover, despite the fact that they had engaged in many breaches previously of the relevant AER rules and law. Then Thorley and ACCC and Google decided to use the 10% of turnover again, despite most of the conduct occurring prior to September 2018. And then there's no clarity in the judgment as to which entity's turnover he's considering. Now, the judgment's strange because Google Australia didn't pay the fine. Rather, the parties wanted Google US to pay the fine. But it's not clear whether the penalty of $60 million is being imposed in relation to Google Australia's turnover or Google US's turnover. It seems to be that it should have been Google US's turnover because they're the one paying the fine, but if that's the case, the penalty would have been very small given they've got a very large turnover. If you looked at the penalty in the light of Google Australia's turnover, it was still very low at 2% of turnover. So that's a case it's very unclear as to what entity's turnover is being looked at to work out whether the penalty is appropriate. And then finally, Murphy in ACCC and Samsung takes a totally different approach and compares the penalty to Samsung's net profit during the relevant period rather than the turnover for the period. So it didn't follow the statute test at all, even though the turnover figures were actually available to him. And as a consequence, he imposed or agreed to an agreed penalty of 0.48% of Samsung's turnover. So what these cases suggest to me is that the courts have been given these agreed settlements and they're not being given the specific reasoning which the parties undertook to arrive at the agreed penalty, and then the court's looking at that reasoning and agreeing to the appropriateness of it. Rather, a number's being put to the court and the court's being given the unenviable task of trying to make sense of this penalty and try to fit it into the statutory language and the statutory regime so that it actually is an appropriate penalty. And I don't think that's a role that the court should be doing. That should be the role of the regulators, to put the proved penalty or the agreed penalty to the court with the reasoning behind it. So just some commentary. I think the decisions I've referred to earlier can't really be reconciled. There's a lot of confusion. Obviously, the ACCC coming to the court with agreed penalty, which does not align with the penalty principles, is a concern, and it puts the courts into this position of having to reconcile the agreed penalty in the statutory scheme. And I think the judgments that come out recently show I think the courts are struggling with that process. They're sometimes using 10% turnover, applying 10% turnover to conduct which occurred under the previous regime, looking at net profit, and also not being clear as to which entities annual turnover is being looked at. And this is all very confusing for business and practitioners. Should be a lot more clarity about how these numbers are being agreed. And I think the idea of the instinctive synthesis is maybe an idea that needs to be jettisoned, because it is a gloss on legislation. It's not made clear in the legislation that that's the approach to take. And it just seems to be a way of saying where the numbers don't make sense, the judge has the discretion to sort of arrive at whatever number they feel comfortable with. And that's really not good enough, I think, nowadays. The argument that the approach to civil pecuniary penalty should not be sequential and mathematical is somewhat open to question, given when you look at the statutory scheme, it does appear to be both sequential and mathematical. For example, the law is set out to say 10% of turnover, $10 million, 3 times the benefit, or 10% of turnover. And that seems very sequential to me. You move from one to the next depending on whether certain requirements are satisfied. It also is a very mathematical process, because the legislation says each breach is subject to, each contravention is subject to a penalty, and then you've got to multiply that by the number of breaches by the penalty amount. It seems like a very mathematical process. So I don't know whether it might be more sensible for Parliament to provide more guidance to the courts to take a more sequential and mathematical process to determining penalties, and to move away from this very vague standard of instinctive synthesis. I guess the next stage from here is hard to tell. The Albanese government has proposed some very big increases to pecuniary penalties to $50 million, 3 times the benefit, or 30% of turnover for the breach period, which are going to significantly increase the penalties imposed by the federal court and are going to result in maximum fines that are through the roof. And that is going to cause greater difficulties to judges in trying to rationalise a penalty that is so much larger. Just using this particular case as an example, if these measure had been used, the new measure had been used in this particular case, the judge would have been looking at 21 breaches of the legislation post September 2018, which would have resulted in a maximum penalty of just over $1 billion. So as you can see, that would have created this judge a lot more difficulty in saying that a penalty of 12.5 million is appropriate in the context of a maximum penalty of over $1 billion. So hopefully you found that helpful. I guess the case is interesting, and I think it's a good guide as to the way to approach the penalty calculations. I think you're seeing Middleton supporting the agreed penalty that was put to it by the parties, but realistically I think there was a different approach which would have made more sense to look at the courses of conduct, and ultimately he's done a pretty good job justifying the penalty put to him. Unfortunately, that's not the case in a lot of other cases which I referred to in the presentation. So if you've got any questions about the presentation, feel free to give me a call or drop me an email. Bye-bye.